This case is about fishing rights in the North Sea, but its enduring importance has much more to do with the way that international law is made. International law is a bit odd because there's no international parliament that can simply make laws and impose them on the world. The United Nations General Assembly is a bit like a world parliament, but treaties negotiated there, big multilateral treaties, still have to be signed up to by individual countries. The Assembly itself has no power at all. But that's still one way that international law is made. There are also bilateral treaties where two countries simply make an agreement with one another. But then, in addition to all of that, there's a concept called customary international law. And this reflects the fact that ever since the earliest times, different peoples and different kingdoms have made arrangements with one another that were basically international law. What this means is that the modern system of international law didn't start with a blank slate. There were already commonly understood rules and practices which allowed the kingdoms, empires, and nations of the world to deal with one another, and many of those customary laws remain intact. That brings us to the facts in this matter. Great Britain and Norway are close neighbours. The coast of Scotland is less than 500 kilometres from the coast of Norway, and both the British and the Norwegians are seafaring peoples. As long ago as the early 1600s, Norway and Britain came to arrangements whereby only Norwegians would fish in the coastal areas of Norway. And it stayed that way for nearly 300 years, until the early 20th century. By the early 20th century, the general rule of nations was that coastal territorial waters extended 4 nautical miles from the low water mark, the low tide mark, on the coast of the country. For most nations and most coastlines, that was entirely sufficient. However, Norway's coastline is famously complicated. Many people know of the fjords, the long deep inlets into the Norwegian coast. Perhaps less well known is what are called the Skiergard. These are a series of thousands of rocky outcrops along the coastline of Norway. Now, strictly speaking, you might call each of the outcrops a tiny island or just coastal rocks, but they've always been regarded by Norway as actually forming part of the mainland. There's evidence of long cultural practice by fishing communities treating the Skiergard as part of the mainland. And so Norway said that its 4 miles began from the outside of the Skiergard, not from the mainland itself. This meant that their coastal waters went much further into the North Sea. Around 1906, British fishermen began fishing in the North Sea close to the Norwegian coast. They were in an area which they claimed was international waters because it was far enough away from the Norwegian mainland. However, Norway claimed that the fishermen were still in Norwegian waters because they were measuring from the outside of the Skiergard. The matter ended up in front of the International Court of Justice, where Norway claimed that it was a matter of customary law, that their territorial limit should be measured from the Skiergard and not from the mainland. In order to deal with this claim, the court had to determine a method for working out whether a claimed customary rule actually existed. And they came up with quite a sensible 3-step process. First, they examined the historical records to see whether there really was evidence of the claimed customary practice. In this case, they found that there was. They looked at a series of decrees issued by Norway over a couple of 100 years, and even on the most conservative view, it was clear that Norway had been using the same system to identify its coastal waters since at least the mid-19th century. The court said the Norwegian authorities applied their system of delimitation consistently and uninterruptedly from 1869 until the time when the dispute arose. But that was only the first element. The second consideration that the court took was to say, well, we've identified this practice. Has it been carried out openly and peacefully? In other words, was the custom that is claimed to be international law something that was done between nations, or was it simply a private policy held by the specific country? In order to review this, the court examined Norway's diplomatic relations with a range of its neighbours, in particular France, and found that Norway had in fact openly pursued the policy of projecting its boundary from the Skiergård. The court said that the Norwegian custom was founded on the vital needs of the population and attested by very ancient and peaceful usage, and therefore may legitimately be taken into account in drawing a line which, moreover, appears to the court to have been kept within the bounds of what is moderate and reasonable. So we have a customary practice that we can show is a long-standing one, and we can show that it's been conducted openly and not secretly. The final element was to consider whether other relevant countries had ever objected to the custom. Because if a nation had a customary practice, but it had always been objected to by the countries around it, well, it could hardly be described as settled international law. Whereas a customary practice that had been conducted openly and accepted by everyone around, well, that starts to look a lot more like something we could describe as law. In this case, the court found that other countries had not objected to Norway's practice regarding its baselines. The court said that France had indicated it was prepared to accept the delimitation laid down by Norway in 1869 as resting upon a practical study of the configuration of the coastline and the conditions of the inhabitants. The court then found that the general toleration of foreign states with regard to the Norwegian practice is an unchallenged fact. For a period of more than 60 years, the United Kingdom government itself in no way contested it. It would appear that it was only in its memorandum of July 27, 1933, that the United Kingdom made a formal and definite protest on this point. As a result of all this, the court formed the view that there was a custom in Norway of measuring its territorial limits from the boundary of the Skiergård, and that the surrounding nations both knew of this practice and accepted it. As a result, as a matter of customary international law, Norway was entitled to measure its maritime boundary in terms of distance out from the Skiergård, and not distance from the low water mark on the mainland. While this case was clearly important to both the United Kingdom and Norway, it has a far greater importance for international law generally. This is one of the key cases setting out the rules for customary international law, and the methods the courts are likely to use in order to identify when customary international law exists. First, the court will ask whether there is in fact evidence of the custom that is claimed. And as a general principle, the longer that the custom has been practiced, the more persuasive it will be as a basis for customary international law. Second, the court will ask whether the custom has been practiced openly and peacefully. Something that is claimed to be a custom, but which has been practiced either secretively so that others couldn't object, or something that has been practiced defiantly rather than peacefully, is much less likely to be considered a satisfactory basis for international law. Third, the court will ask whether there have been actual objections to the custom from other countries. So the court's not looking for acceptance as such. The court's looking for objections. If there's no record of consistent objection, then the practice is much more likely to be considered customary law. In this way, the practices that have emerged between nations over time can be adopted by the system of international law. These days, the formal system of international law has been operating for roughly a century, and the United Nations for nearly 80 years. It's unlikely that there's much more customary international law out there to be discovered. But if it does emerge, the rules established in the North Sea Fisheries case will still guide the court's recognition of those rules.